Item 15, trustee education regarding Internal Revenue Service requirements for qualified retirement plans, the exclusive benefit rule, and the corrections presented by tax counsel Robert Goss, partner at Andrea Ferguson, partner Ice Miller, LLP. Receive educational training, 45 minutes trustee education credit. All right, do we have the folks from Ice Miller?
Mr. Chairman, we are approximately 2 hours in, and this next item is going to be lengthy. Now might be an appropriate time for a 5-minute break, but pleasure of the chair and the board.
All right, 5-minute break. It's 10:25 now. We will be back at
come here.
Excuse me. We will be back at 10:31. 10:31. I know we're missing a couple people. Amy, do we need roll call again, or we don't, do we? Okay. All right. The folks
Mr. Chair,
from...
I'm just making sure we have a quorum for just a second.
Okay.
Some people have their screens off, so I can't tell if they're there.
Robert, do they make you wear a suit to show up to office with nobody there?
This is just for you, Mr. Chairperson.
Man, I would have wore my best tie. I failed. I'm sorry. What office are you guys out of, Robert?
Indianapolis.
Ah, very nice.
Okay, Mr. Chair, we have 5. We can proceed.
All right, we are reconvening back at 10:32 hours. We are on item 15, trustee education regarding Internal Revenue Service requirements for qualified retirement plans. And I will let either Robert or Audria, whichever one you'd like to start.
Yes, thank you, Mr. Chairperson. Thank you, members of the board, and also thank you to Dominic and Jennifer for this opportunity to speak to you today. I'm Rob Goss, and together with my law partner, Audra Ferguson Allen, we're partners in the law firm of Ice Miller, as you might have heard, primarily located in Indianapolis. And we practice exclusively in the area of federal tax compliance, in the design, operation, and administration of governmental defined benefit and DC plans. We work with both large statewide plans and systems, and then local single employer plans and systems in approximately 40 states. We've worked with KSARA since approximately 2013 and represent a number of both 37 Act and non-SURL plans in California. Amy, next slide. So for today's training, we want to discuss with you the following topics. First, a background on qualified retirement plans and what it means to be qualified under the Internal Revenue Code. The exclusive benefit rule and its impact and import for a qualified plan. And then plan corrections and the established procedures from the Internal Revenue Service in terms of making corrections. I think both Audra and I at different times will refer to the code or the IRS, and we hope you'll just know that when we say that, we're referencing the Internal Revenue Code and the Internal Revenue Service. All right, at this point, I'll turn it over to Audra.
Thanks. So between the introduction from Mr. Chairman and Rob, I'm sure this is sure to be a riveting educational session, but no, Rob and I keep it somewhat educational, plus we try to keep it interesting as well so as not to lose our audience. So to start off, we are talking about qualified retirement plans, and what we're talking about are 401A plans, such as the KSARA plan. And this is the most common form of retirement plans that you see within governmental retirement systems. So most governmental retirement systems, their plans are established pursuant to Internal Revenue Code 401A. And so Internal Revenue Code 401A provides the qualification requirements. So those are the requirements we're going to be talking about today, including tax-favored treatment, which we will also talk about in a little bit more detail here soon. But you should also be aware that there are other types of retirement plans that government systems may have available to them as well. Although we won't be focusing on those plans for purposes of this presentation, it's just good to be aware that those are out there because you may hear some discussion about that. Plus, there are other requirements that apply to those plans, so that's why it's important if you're talking to people in another retirement system or friends who may be talking about their retirement plans, that you understand that there are distinctions among those types of plans. So some of the other plans that may be available to government retirement systems are also known as deferred comp plans, deferred compensation plans, 403B plans. Now those plans are only available to certain types of employees. So in the governmental sector, where you most often see those are in education, and it also can be in a public hospital, governmental run hospital can have 403B plans. And then there are certain types of non-qualified plans, such as 457F plans and 409 Cap A plans. There also could be some grandfathered 401k plans, so we always try to make the distinction that governmental plans are not subject to ERISA, and that is true, but there may still be some governmental retirement systems that have older 401k plans. You can't have those now, but there are some older ones still out there. So next slide. So we're going to be talking about the qualification requirements, and there are a lot of different sources for those qualification requirements. All of the sources are built around the Internal Revenue Code. So as Rob mentioned, we will talk a lot about the Internal Revenue Code. Despite the fact I refuse to call myself a tax attorney, that is really what we are focused on is the IRS and the Internal Revenue Code. And then on this slide, everything sort of builds out from the Internal Revenue Code. So that can include revenue rulings. We will talk about revenue procedures. Sometimes we call those Rev Procs. We will talk about that when we talk about the correction requirements, because those are set forth by the IRS in a Rev Proc. There are private letter rulings. So a taxpayer, which can include a retirement system, can go to the IRS and ask for a ruling. So you have to pay a user fee, and you can ask for a ruling. It's not binding on anybody except for the taxpayer to whom that ruling is issued to, but the private letter rulings can provide really good guidance on how the IRS views a certain factual scenario. Notices, so we have had some recent notices from the IRS that have been really important in providing guidance on how to implement the CARES Act and the Secure Act, so the two acts that were most recently passed by Congress. And so those notices provide quick guidance from the IRS, the Department of Treasury, regarding how to implement those acts. And then, of course, announcement and newsletters. And really, I would say second to the code are the Treasury regulations. So those are regulations in the code. And so we will talk about those different forms, but those are where all the qualification requirements are housed. So next slide. And so, you know, it may be important to take just a step back for a moment and think about why do we care so much about whether or not a plan is qualified? What really are the advantages? And there's really no other way under federal law for members to have these tax benefits unless the plan is qualified and continues to remain qualified. And that's why it's important to keep this in mind when we're talking about the different requirements, and certainly when we talk about error corrections, that the main focus is to make sure that the plan remains qualified for all of these advantages. So for the trust, one of the advantages is that earnings are not taxable to the trust. There can also be tax recapture that's available in tax treaty countries. For the employer, there are benefits as well because there's no employment tax on contributions. For the member, there are certainly very important tax advantages as well. Employee and employer contributions are not taxable as income until distribution. So if picked up contributions are made, those can be made on a pre-tax basis. There's also favorable tax treatment upon distribution. So certain distributions can be rollover eligible. So if that is, if there's a distribution that is rollover eligible, then the member can continue to defer taxation when they roll over the funds until they reach a certain date. And then again, for the member, there is no employment tax when contributions are made or when benefits are paid. So certainly there are some very big tax advantages, and if a plan were to ever become disqualified, that would be a huge taxable event that would be adverse to the trust and to the members as well. Next slide. So how can a plan know that it's qualified? And one of the biggest ways is to get a determination letter from the IRS. So an IRS favorable determination letter is an opinion from the IRS that the plan is qualified under Code Section 401A. So again, that is the code section that we are focusing on. And to the determination letter, and I should say KSARA does have a determination letter. So some people refer to the determination letter as an insurance policy. That's how important that determination letter is, because it protects a plan from being challenged as not qualified on account of its written terms. So certainly there could be operational failures, but based on the plan's written terms, the IRS signs off that the plan is qualified. And it also means that the plan has met all of the requirements. Again, going back to that slide, Amy, you don't actually have to go back, but thinking back to the slide that has the code, the regulations, all the sources of qualification, it's the IRS's way of saying these meet all of those requirements. Now, once the IRS issues the letter, the IRS is bound by that determination until either the expiration of the letter changes. So the law can change such that the plan still needs to be amended despite the fact it has a current determination letter. And we're going to talk about the expiration date as well, because under RevProc, so again, we talked about those revenue procedures. Under RevProc 2016-37, the IRS really curtailed the determination letter program. And what the IRS did was they said, we are going to limit your ability to come in for a new determination letter. And they did this for a couple reasons. One, the amount of resources that it was taking from the IRS to these letters was, as you can imagine, pretty substantial. So the IRS was really trying to encourage plans to use volume submitter plans, also known as master prototype plans, where a system can just sign on to a plan that's already drafted. But that doesn't really work very well for governmental plans, because governmental plans have unique features. They have, there's sometimes collectively bargained provisions in there as well. So those types of plans don't really work for governmental plans. So now to get a new determination letter, it either has to be the first time you've applied for one. So again, as I mentioned, KSARA already has a determination letter, so they wouldn't be able to go in for a new one, or upon plan termination. So what this does is it really puts a lot of the onus on the board and attorneys and consultants in making sure that the plan remains qualified. So making sure the plan is up to date with any changes under the federal law. As I mentioned, there were some changes under the Secure Act and the CARES Act that did require changes to plans. Now for governmental plans, there is a long period of time before those written plan changes have to be made. But again, it's very important that those changes be tracked and that you consult with your counsel to make sure the plan remains qualified, given the fact that you can no longer go in for a new determination letter. Now, going back to the expiration date, I mentioned that your determination letter is good until the expiration date. But under that Rev Proc 2016-37, the IRS says those expiration dates are inoperable. So meaning that it no longer has an expiration date, it's still valid except for changes under federal law and any changes that you make to the plan after you receive the determination letter.
Let me just add there, as Audra, thanks, Amy. As Audra mentioned, there were a number of reasons why this program was dropped. A practical reason was that the program was administered through the division of the IRS that's referred to as the TEGE section. That's tax exempt and governmental entities. That section came under a lot of scrutiny for the tax exempt portion because that is the section of the IRS that was approving 501c3 applications. And you might remember a number of years ago, there was some concern that those applications were getting too much attention if they were from a certain political viewpoint or approach. And so Congress, as a reaction to that scrutiny, started to limit the amount of funding and support that was going to the IRS, and in particular to this part of the IRS, which caused the IRS to have to say, we can't do more with less, we have to do less with less. And this was one of the programs that then got cut back, or in this case, it was frozen. When we say individually designed, the fact that KSARA's plan is composed of state law, the 37 Act, and changes under the Act, as well as board rules, that's individual design. It's not a off-the-shelf type of plan that's already been pre-approved through the IRS. Record keeper plans often are that type of plan. So when the legislature amends the plan, such as it did with PEPRA, we used to be able to take those amendments to the IRS to get them blessed and not affecting the qualified status. And we're no longer able to do that. So this change in the program creates both an operational compliance consideration, as Audra mentioned, but it also creates a fiduciary obligation or consideration to make sure that the plan is remaining current with any required changes, so that as written, it meets the qualification requirements. And then from a fiduciary standpoint also, to make sure it's being operated in compliance with those different qualification requirements. Okay. So with that background, we now want to talk about the exclusive benefit rule. And I've summarized the rule here. We've summarized the rule here. It comes up under Code Section 401A2. Remember, these are 401A plans. And so this is a subsection under 401A. And in essence, this section makes it, or prohibits, the use of plan assets and the terms of the trust must be set forth to prevent or prohibit those plan assets from being used for any purpose other than for the exclusive benefit of employees and their beneficiaries. You see here, this is a quote from 401A2. The plan must make it impossible for any of the corpus or income to be used for or diverted to purposes other than for the exclusive benefit. Now, the exclusive benefit rule does allow for the payment of reasonable, appropriate, and allowable expenses under the plan. The plan terms have to allow for that, but to pay for reasonable fees and expenses is allowable so long as the plan also allows for it. But keeping in mind that this is a qualification consideration or requirement under the code, it's not exclusive to just the Internal Revenue Code. So as Audra mentioned earlier, ERISA, which does not specifically apply, but ERISA has a similar exclusive benefit provision. It also comes up under the fiduciary duties of loyalty and prudence, that there's a fiduciary requirement to prevent the use of trust assets except for the exclusive benefit of the employees and their beneficiaries. And as a prelude to the next topic, it's important to consider that the overpayment of a benefit is considered a violation of the exclusive benefit rule because it constitutes the payment of a benefit to which someone was not entitled under the terms of the plan. So looking at bullet 2, when we have an overpayment, we've now used corpus for a purpose other than the exclusive benefit of those employees and beneficiaries because we've paid an amount that the individual was not entitled to. Go back real quickly, Amy. Also, please just consider that the exclusive benefit rule not only applies to the plan as written or the trust of the plan, it's also a consideration in investments, and it's a consideration in prohibited transaction rules and consideration of prohibited transactions. Okay, next, Amy. So now we want to talk about plan corrections. And this comes up, as Audra mentioned, we're going to reference a RevProc, a revenue procedure. It's most recently been updated at Revenue Procedure 2019-19. This is a living document. So every couple of years, the IRS updates it and sends out an updated version where they redline what has been changed. So this is the most current version, but we can go back in time and look at other versions and see how this system has changed over time. It's referred to as the Employee Plans Compliance Resolution System. We generically refer to it as EPCRS, and that's probably what I'll end up doing at different points this morning. But this is the set of instructions from the IRS as to how a qualified plan can correct, either correct itself or go to the IRS for correction when it has made an error. Under EPCRS, errors get a much dirtier term. They're called failures. So it seems much more severe than just a mistake, but that's what we're talking about. We're talking about errors under the plan. And EPCRS addresses, for our purposes, specifically 3 different types of errors. Operational failures, which are where the plan has failed to follow the plan terms. So when we look at the terms of the plan, from an operational standpoint, we've done something different or contrary to what the terms of the plan say. That's an operational failure. Also, we have a plan document failure, which is the failure of the plan to be in compliance with the code and regulations. I think the last time KSARA went in for its determination letter with other SURL plans, it did so as part of both a determination letter and a VCP filing. That's a voluntary correction program filing, which we'll talk about in a little bit. But there were a number of code section qualification requirements that had not been adopted into the SURL. And so there were consolidated filings to adopt various board rules or resolutions in order to bring those compliance requirements into the plan as written. And that's a plan document failure. And then we also have an employer eligibility failure, which is the adoption of a plan by an employer that's not eligible for that type of plan. So going back to Audra's earlier comments on a grandfathered 401k plan, if a governmental plan wanted to adopt a 401k plan now, and it did, that is an employer eligibility failure because governmental employers are no longer eligible to adopt 401k plans. So that would be a type of failure that would have to be corrected under EPCRS. When we look at the operational failures, I want to point out, thank you, that these can be addressed through board policy, and the policies that we want to talk about or think about today are the board's overpayment and underpayment policies, which become an extension of the plan's terms and allow for a consistent approach to address a certain type of repeat error or failure. Okay, next, Amy.
Rob, can I interject for just a moment? So
yes, Dominic.
You know that we're dealing with this partially because we're dealing with this Alameda decision. And so I just want to clarify the terminology that's being used here. You know, this is a new court decision that came down. I wouldn't characterize it as a failure per se, but it was a new court decision that must now be implemented. Can you comment on just using that backdrop and how that interacts with the slides and how the IRS sees it? Does the IRS see it as a failure regardless of the fact that it wasn't, maybe meet the normal definition of a failure? How does that part work?
Yeah, great question. Thank you. So I said failure to follow the plan terms, and the plan terms are all just as EPCRS is living, the plan terms are living. They change. They change when the legislature passes amendments to the plan terms, but they also change, as we have in the Alameda decision, when there's been a ruling under state law that addresses or interprets the terms of the plan. So we know that Alameda addressed pay codes and resolutions that had been adopted in implementing PEPRA. When that decision comes down, the decision might be, and I'm just speaking generically here, the decision might be retroactive or the decision might be prospective. And in either case, that interpretation of those plan terms becomes new law that we have to consider as a board in whether or not to change our operation and approach going forward prospectively, or whether or not the decision has a retroactive effect and we need to make operational changes or implement the decision looking retroactively. Those would be considered errors. It might only be a error in the way the plan is drafted currently, and so we're changing that to look forward, or the application of the plan terms we're changing prospectively, but there might also be a retroactive application that has to be considered. And it's in both of those contexts that we talk about the correction and the change of those plan terms by virtue of the legal landscape related to the plan. Dominic, does that answer your question?
Yeah, so the IRS looks at it as an error, even though we would say, well, it's not an error, no one made a mistake, it's a different court decision. But the IRS has it in the broad category of it's a correction of an error.
That's right. And we can utilize this EPCRS system in order to correct or to make the correction that's required by virtue of that change in state law or by virtue of the change in state law because of a court decision.
And I think, too, it's important to keep in mind the distinction between whether or not there was an error, such that the court said the plan has always been this way and we are interpreting it this way and you need to make changes, versus a change in the law, which, as Rob said, there's retroactive changes and prospective changes, and certainly a change in the law, which from our viewpoint then means the plan has now changed, may end up resulting in a different way or a view that there really wasn't an error because the law has changed and there has now been a plan document change. So there is a distinction in looking at that decision too as well.
And we'll talk about this in a little bit more detail later in the slides, but there also can be state law and court decisions that limit our ability to correct. And the IRS takes into consideration that the plan has to apply all of the law related to the plan and make decisions regarding corrections which might be limited because of other legal requirements or common law interpretation. Okay, Amy. So EPCRS has several different general principles which underlie it. And think about EPCRS as a program that the IRS established for qualified plans and plan sponsors to identify and correct their errors, their failures, and also think about the fact that EPCRS has identified errors, identified failures, and examples of those errors or failures and a corrective approach. So under these principles, the IRS says that EPCRS is intended to encourage the establishment of administrative practices and procedures that ensure a plan operates in accordance with the code. Again, you've got board rules that bring forth requirements under Code Section 401A9, for instance, that is required minimum distributions, or board rules under Code Section 415B, the limit on the amount of benefit that can be paid. But EPCRS also encourages administrative practices and procedures like the overpayments policy or the underpayments policy that provide additional approach for ensuring compliance with the code. The next principle is that EPCRS wants to ensure satisfaction of the code's plan document requirements. So a regular review of the plan to make sure that amendments have been adopted. A good example is the Secure Act and the CARES Act, each of which had different either mandatory or permissive amendments that could be made, changes that could be made, and then a deadline by which employers or plans need to make those amendments. And the deadline is dependent on whether you're private sector or a governmental plan. Governmental plans have a different deadline. But EPCRS encourages, the principle is to encourage that those plan document requirements are being reviewed and satisfied on a regular basis. EPCRS wants to encourage voluntary and timely correction. So a principle of EPCRS is to allow the plan to correct itself without having to go to the IRS to get relief or permission of the corrective approach. There are times when you need to or should go to the IRS. We'll talk about that in general terms, but the IRS really wants to encourage a plan to be able to timely correct itself. We've got the principle for consistent and uniform administration. This is where policies become so important because we have certain types of errors that are regular, they're common, and we want to make sure that those common errors are being corrected in a common way. And this is where the EPCRS examples come in are so handy because it allows us to look at the examples that the IRS has given and to know that the corrective approach that the IRS has said, this is an approved approach. If you follow those approved approaches, then the plan has reliability that you've satisfied the corrective approach as approved by the IRS, and so your qualified status will not be impacted. And then EPCRS also wants to encourage, or the underlying principle is that if you follow these approaches, then you are correcting in a manner that is consistent with fiduciary principles. So the corrective approaches not only give a roadmap of what the IRS has said is an approved approach, but it's an approach which the IRS believes is consistent with fiduciary principles. And I'll just pause right there and open it up for Dominic or anyone else, any questions or comments related to that.
Any board member have any questions? I can't see your screen, so just chat if you have any questions.
Trustee Robinson has his hand up.
Okay, Trustee Robinson.
Yes, Mr. Goss or Ms. Allen. So how is the distinction made by EPCRS as it pertains to our fiduciary responsibility, or I'm sorry, our plenary authority, the board's plenary authority to administer the system, whether it may adversely impact the status, IRS standing or not with fiduciary principles? How is that? I just don't see. I understand we're obviously going to act in the best interest of the board, but doesn't that seem as though it's two conflicting concepts?
You're absolutely right. There are conflicting concepts at play, some of which we're going to talk about here. We want to give you the general principles under EPCRS. Going back to the question that Dominic asked, the IRS also recognizes that there might be limitations based upon state law, and that could be state law as written by the legislature or state law as decided by state courts, and that any correction, since we're talking about EPCRS here, any correction has to be considered in the context of those state law limitations. The other part of the question that you hit on, and it's a great question that we do not necessarily have a great answer to, is that there are going to be fiduciary limitations related to that correction. And so I'll take an overpayment as an example. Not to steal thunder from a little bit later in the slides, but in general, EPCRS would say that you correct all overpayments for all years. Well, a overpayment of a certain dollar amount when the individual might be hard to find or just might not have any resources to repay that overpayment, that's going to create a fiduciary consideration for how much should we spend in trust assets to chase an overpayment of a certain dollar amount. And I think you've already made some of that decision in the board's policy related to overpayments and underpayments. You've taken some of that into consideration. The reason I say there's not a very good answer is because the IRS has not specifically addressed that in EPCRS. Back in 2015, we sent a letter to the IRS encouraging that EPCRS be amended to specifically consider fiduciary considerations. It hasn't done that yet. And part of the reason I think it hasn't is EPCRS is a general procedure that applies to both ERISA and governmental plans. And so it's not specifically drafted towards governmental plans. It also applies to ERISA plans. And these fiduciary considerations, although they apply to all trustees, some considerations are unique in the governmental context versus the ERISA context. Does that help answer your question?
Yes, it does. Thank you.
You're welcome.
Robert, I have one other question. One of our members emailed us a couple of days ago and asked about Revenue Procedure 2008-52. I took a brief look at it. It seemed to have a lot of the same language that is in 2019-19. Do you know if those are the same, if that was an updated version of the same one or something else entirely?
Yeah, no. So 2008-52 was an earlier version of what is now 2019-19.
Okay, very good. Thank you.
You're welcome. Okay, Amy, next slide, please. So we've talked about this a little bit. From an administrative practice and procedure standpoint, EPCRS encourages that the board establish procedures so that the qualified plan is operated in accordance with the applicable code requirements and other related regulations guidance. Remember the pie chart that Audra had early on with all the different types of guidance that we get from the IRS, some of which is binding, some of which is not. But we look to it because of the decision that the IRS has announced. And so EPCRS wants to encourage us to have those established procedures. And if we do, EPCRS allows for the use of self-correction. As I mentioned, it wants to encourage us to self-correct. These procedures allow us to take advantage of self-correction. And then I also mentioned that one of the principles of EPCRS is that we should have consistent correction or application of the principles to similar circumstances. And that is an underlying principle, is encouraging us to have consistent corrective approach. Next slide. At this point, I'll turn it over to Audra.
So what we're talking about here are some of the overarching principles for EPCRS. As Rob mentioned and discussed, there can be other considerations that have to be accounted for, such as any restrictions under state law. But these are just the broad principles. And again, as Rob talked about, when we talk about EPCRS, it applies both to private sector and governmental plans. So certainly governmental plans have some unique challenges to them that are different from the private sector. But one of the overarching principles of EPCRS, which makes sense, is that the correction method should restore the plan and the participant to the position it would have been in had the failure not occurred. So that makes sense from a general, broad perspective, is that we do want to make sure that everyone, the member, the beneficiary, the plan, the employer, everyone is back in the same spot that they would have been had the error not occurred. And as part of that, the IRS says, and all years need to be corrected. Well, again, that is a general proposition that sometimes there are restrictions to that. So there can be some state law restrictions with respect to recovery. There can also be restrictions with the IRS with respect to how you make a full correction. There's the concept of open tax years and closed tax years with the IRS. So broadly speaking, open tax years are the last 3 years are open tax years. And closed tax years are anything after those 3 years. And so what the IRS says, again, very generally, broadly speaking, is that you can't make any changes to your taxes in a closed tax year. The IRS says we can't come after you, you can't come after us in a closed tax year. And so sometimes those come into play when we're talking about corrections. So again, we do have this overarching principle that we want to make a full correction. When we talk about a full correction, what we're talking about is putting everybody back in the place they would have been, including the plan. But sometimes there are other factors that have to go into that consideration when we talk about a corrective approach. And the correction method must be reasonable and appropriate and consistent with IRS guidelines. So as Rob mentioned, when we're talking about an overpayment, so if we're talking about, let's use the example of a $200 overpayment, and you can't locate the member or you've been unable to contact the member, it doesn't make sense to then spend $10,000 to try to recover a $200 overpayment. So it has to be reasonable and appropriate and certainly consistent with IRS guidelines. And consistent with IRS guidelines means that it follows the general principles. Every fact and every situation is different and unique, so it may not always fit perfectly within the IRS guidelines, but it should at least be consistent with the general principles.
Hey, Audra, can I jump in here real quickly? I just want to go back to a question that Dominic asked earlier. As Audra says that we restore the plan to the position it would have been in, what often happens in the case of an overpayment, so someone has been paid more than they should have under the plan terms because there's been an error in the calculation of the benefit. Well, there are two sides to that error. One is what was paid in the past, and the other is what will be paid in the future. And so correcting the benefit to what it should be is part of the correction that's being discussed here, is that we're recalculating the benefit at what it should be under the plan terms. And by plan terms, I also mean state law interpretation of those plan terms.
I think we have a question from Mr. Robinson.
Yes, are there any limitations on how much of an effort must be made by our board in order to recoup an overpayment?
That's a great question, and unfortunately, the IRS at least does not set forth exactly how you determine what that effort is. So the way most systems take care of it is they have a general outline, broad outline in their overpayment policy that sets forth how they are going to try to recoup the overpayment, any limitations they may have, or categories with respect to the efforts that they're going to undertake. From a fiduciary perspective, having a written policy like that that's reasonable and can be applied consistently can go a long way in fulfilling your fiduciary duties with respect to these overpayments and trying to balance the cost of recovering the overpayment versus the overpayment itself.
And then let me just add, there are some additional considerations that we'll talk about in this afternoon's session as well, where limitations might come into play.
Right, because what I'd really be interested in knowing is first, you've answered my first question, is if there's any kind of language or regulatory language there that's saying, hey, you guys can't be doing harassment, or I know that, like Patriot Act, certain things with vets, things like that, or vet service members. So I didn't know how that tied in with us, but also I'd be really interested in seeing what it looks like as far as so it sounds like you're saying that it's all on the agency to kind of develop that policy and move forward that way. But also, what about I guess if you just can't get in touch with someone, you just I know you said, well, we have to weigh the cost. Then how do we move forward? Is that still a part of the policy as well? Is that a part of this the EPCRs? Are they addressing that?
So the IRS certainly addresses lost and missing participants, and so it sets forth some steps that should be taken if you can't get a hold of a member or beneficiary regarding their benefit. Unfortunately, it doesn't fit exactly within the overpayment policies because it's really talking about if you have a member or beneficiary who is owed a benefit and you can't contact them, the steps that you should take that are deemed to be reasonable. So those steps can be implemented. They're fairly straightforward. I think it's basically sending certified mail to the individual, trying to look at what records you have with respect to other contact information for the individual or beneficiary, using free internet searches that are available to try to contact the member or beneficiary. So certainly those are some easy, straightforward steps that can be taken. As mentioned, they're not always, it's not exactly right on point with respect to an overpayment. And it also is going to depend on the amount of overpayment. So systems take different approaches. Some statewide systems will say we're going to turn the matter over to our AG's office, and they are going to go through a collections process to try to collect the overpayment from the member. Some will say we're going to go straight to the employer and ask the employer to make up that overpayment, and then the employer can try to get it from the member or beneficiary, particularly if the member is still employed. So systems handle it different ways, and certainly the amount at issue really comes into play. Again, if we're talking about a $200 amount versus a $200,000 overpayment, that can really determine what steps will be taken to try to recover that overpayment from the individual. Amy, let's go to the next slide.
Mr. Chairman, it looks like Trustee Sibley has his hand up.
Okay, I'm sorry, I can't see any of you guys because we have the slides up. So just butt in, Trustee Sibley.
Yes, I would just like to add to the question that Audrey just came up with, and so I don't have off the top of my head what the county's position is, or what their position is on getting money back, retrieving money. So if someone has a pretty large amount, let's say over 3 years, they've been, paid X number of dollars that technically now has to come back, and it's a hardship. Now I'm talking about, let's say, a retiree, not someone who's working. So they're living on a fixed income, and now they're told they got some money that, hey, sorry, we paid you too much. Not that it was their choice. That's what they got paid in their retirement. So Audrey, asking you, because you all are the IRS, is the IRS, do they have any, I'm looking under the reasonable and appropriate slide. I'm not exactly sure how to ask it other than, is the IRS going to say, you have to collect X number of dollars back? And I know you've sort of spoke of that. Are they holding us to, we have to get X number of dollars back? Or are they giving us the authority as the county to figure out what we feel is appropriate without destroying someone's life, so to speak, because now, I mean, they're budgeted and they got big money they have to turn back. And although we might stretch it out to 3 years, it still could be kind of a breaker as far as their living expenses and what they do. Is the IRS going to hold us to getting back? I hate to say this, I'm not sure how to ask the question other than I don't want to destroy a person's life. Certainly we won't make them homeless, but I don't want to destroy a person's life if we don't have to.
Mm-hmm. Yeah, and that's a great question. Certainly I'm not speaking on behalf of the IRS, and I can't speak to how they would view an individual circumstance. I can speak from experience in other overpayments with the IRS that it garners not as much sympathy as you and I would like to see from the IRS in those types of situations. Certainly there may be state law restrictions, and the IRS may heed any state law restrictions, but from a federal law perspective, when we have been to the IRS for overpayments on a VCP where it was fairly sympathetic, it was many retirees who were not at fault for the overpayment, and it was going to result in a substantial reduction in the retirees' benefit to offset their benefit to recoup the overpayment. The IRS has taken a pretty hard line, and that line is that the overpayment has to be corrected, and it either needs to come from the member or it needs to come from somewhere else. And so sometimes systems say, well, we will deal with that somewhere else by having the employer or the county or the state make an additional contribution to make up for that overpayment. So that's where there can be some flexibility on the board. Where the IRS says it's really not acceptable is just to say we're going to forgive the overpayment and move on. Rather, the IRS says, well, you need to make the plan whole, particularly when we're talking about a defined benefit plan, because going back to the exclusive benefit, that those plan assets are for all members and beneficiaries. And if one member has received more than they otherwise were entitled to receive, it's viewed by the IRS as a windfall to that individual, which really adversely impacts the trust fund as a whole. So their position is they don't get too wound up as far as where those funds come from, whether it be from the member or whether it be from the employer, but they do take the position that the plan should be made whole for that overpayment.
Mr. Chairman, I want to offer one comment, and then I saw Jennifer had her hand up, so I would like to hear her thoughts on this as well. But Rob, to your question with the county, one phrase that I became very familiar with the county was gift of public funds. And because gift of public funds is strictly prohibited, then the county has certain rules about how they seek recoupment of overpayments. But we as a plan and as fiduciaries of the plan fall under very different rules as a 401A plan, which is completely separate from the county with regard to this. So that's why we are a little bit different and have different discretion than the county with regard to that. So Jennifer, do you have other comments on that?
My comment was actually to a little bit more, in addition to what Audra and Rob already provided with regard to Trustee Sibley and Trustee Robinson's question about how harsh or what would we consider for your benefit, since you are newer trustees on the board. These were all the types of questions that the trustees considered when the correction of the overpayment and underpayment policies were revised to separate them into two separate policies, now one for corrections of contributions and now corrections of benefits for retirees. And a policy which I would add that ICE Miller assisted us with. All the questions about, what about hardship situations? And so, as Audra was saying, the IRS has the general rule, but they also allow for some reasonableness and consistency, and that those considerations are included within both of our policies. So the policy itself already speaks to how we would address certain situations and requires the consideration of a bunch of different factors. It gives discretion depending on how the amount of the correction or overpayment. Some at a certain level, it's board discretion. At a certain level, it's executive director discretion. And then all of those types of situations, hardships included, can be considered and evaluated. But that is contained within our policy as it currently exists, based on what the IRS generally requires. And then for certain situations, we can't find the person, hardship, we can't collect anything even if we wanted to. We have we have guidance about how we would handle those types of situations.
Well, I appreciate all that information, and the only reason I brought it up is if a person doesn't have the opportunity to either be in or out, in other words, I'm not so sure, and I could be wrong on this, I'm not so sure that at the time that what was being taken out is now can't, that someone was even asked, do you want it taken out or not? So you didn't have that authority. So it's not like, fortunately, I don't think I'm on that list. Who knows? But especially retirees, if that's just the way it was tallied, this is what your retirement's going to be, and no one gave you a choice of, do you want to, it was just part of what was considered. It's not like the person tried to get something. And what I see, they weren't doing anything wrong. They were just happy to accept what they were being given in their retirement. And now we have the problem of all of a sudden something's being taken out that they didn't ask for in the first place. It was just part of it. So I'm not saying anyone's right or wrong. It's just I have a problem. I just have a personal problem with all of a sudden someone coming back after you. But I appreciate it, and maybe this all can be resolved easily, but I've just had that personal problem I wanted to bring up.
I don't think you are alone in that view. Those are the discussions that definitely happened at the board level, because a lot of these times, majority of these times, corrections are either changes in the law or calculations, the computer didn't catch something, or not something that the member was aware of or wouldn't even have known to be aware of. And that is the harshness of the situation. But going back to what Rob and Audra talked about, exclusive benefit rule, compliance with the plan, making sure you're operated in accordance with the plan, that's really the touchstone. And then we just include the reasonableness factors when we evaluate the ability to pay back those corrections.
I know that
I have a question. This is Jordan.
Jordan,
Sorry.
go ahead.
Sort of a question / statement maybe. And I don't know if it's already addressed in our policies, but sort of how much discretion do we have in relation to how, say, if the decision's made that we have to collect, not only lower a benefit, but collect back overpayments, how much discretion do we have in sort of saying what the time frame is over which we would collect overpayments? I know that there is some discretion there that we don't necessarily have to say, and the county does this as well, that we don't have to say you owe it all back now. We I believe have the discretion to say, look, we can establish a payment plan. You have up to so many, even possibly years, to pay it back. Do we have sort of full discretion over that, or does the IRS have any guidelines? Can we say, yeah, you owe us all this money back, but you have 100 years to pay it back? I mean, obviously I'm being facetious there, but do we have full discretion there, or are there guidelines, or I don't know. That's my question.
So you have a lot of discretion there. Certainly, I don't think the IRS would want to see a payment plan going past somebody's life expectancy. But you can certainly set up a payment plan for retirees. One of the most common ways overpayments are recouped from a retiree is from an offset. So you would do an actuarial, not you, but your actuary would do an actuarial calculation over somebody's lifetime and then reduce their benefit to recover the overpayment over somebody's life expectancy. So that is a very common way to do it that seems to have the least adverse impact on the member. And then it helps from a member's taxation standpoint too, because if for example, their benefit was $500 a month, and then with the actuarial offset now they're only receiving $300 a month, they're only taxed on that $300 amount. So it helps the member from a taxation standpoint in addition to spreading out the repayment over their lifetime.
Thank you. That's helpful to know. Thank you.
Any other board members have any questions? Just jump in if you do.
Mr. Chairperson, I know that we've run a little bit past our allotted time. I was going to suggest we've got just a couple more points that we would want to make, and then I know some of this discussion we'll have this afternoon as well. So if appropriate, Amy and Audra, maybe go to slide 16.
Sure.
Yeah, so this sums up really the correction requirements and principles. A full correction is what the IRS looks for, but there are some exceptions, and we've talked about a lot of those exceptions here, including if it's a small overpayment or a small benefit that was provided, and certainly we have the state law restrictions that we have to consider as well as open-close tax years. Again, restoring the plan in the position it would have been in. This includes an interest component from the IRS's standpoint as well. Again, because we're trying to put everybody in the position that they would have been in had the error not occurred, which includes an interest component, that it be reasonable and appropriate for the failure, consistency among all types of that failure and plan years, and really trying to keep the assets in the plan. So not moving assets in and out of the plan is something that the IRS really is looking for as well. And again, these are just broad principles that we're talking about, and all factual scenarios and plan requirements are different.
Right, especially on that last point about keeping assets in the plan. If there has been an overpayment of contributions by the member, the corrective approach is going to be different than if there has been an overpayment of contributions by the employer. So just keep that in mind, that the same type of error might require a different result depending on who's involved in the error. Amy, the last slide, please. So we've talked about EPCRs. We focused on overpayments. That's not the only common issue that's identified under EPCRs. We've listed here some other common issues that governmental plans and sponsors frequently deal with, and that are also addressed by EPCRs. Just know that in these types of situations, there are specific approaches outlined, and certainly Jennifer or us would be glad to talk about those corrective approaches with you. And so with that, that completes this part of our presentation.